You've been told that Roman law represented the pinnacle of ancient legal sophistication, a system so advanced it forms the foundation of modern Western jurisprudence. But hidden within its most celebrated framework, the gentium, the law of nations, was a mechanism that legally stripped foreign queens of protection, making their bodies and kingdoms fair game for systematic exploitation that Roman legal scholars didn't just permit, but actively codified. Right now, in law libraries across the world, there are Roman legal texts that contain explicit provisions explaining how foreign royal women fell into a category of legal non-personhood the moment they entered territories under Roman jurisdiction. And what happened to them under this framework reveals something historians have been reluctant to examine. The machinery of empire wasn't just built on military conquest. It was built on legal instruments that transformed the abuse of foreign noblewomen into administrative procedure. Listen carefully to what the gentium actually meant in practice. Modern legal scholarship celebrates it as Rome's enlightened framework for managing relationships with foreigners, a universal law that transcended local customs and recognized common human rights. That's the sanitized version. Here's what the actual Roman jurists wrote. The gentium established that foreign nationals had limited legal standing in Roman courts, that their property rights were conditional, and that their personal status depended entirely on whether Rome recognized their sovereignty. For foreign queens, women whose authority derived from non-Roman kingship, this created a catastrophic legal void. They weren't Roman citizens, so they had no protection under ius civil, the law of citizens. They were royal, so Romans refused to treat them as ordinary foreigners under standard ius gentium provisions. And their gender meant that Roman law, which granted married women almost no independent legal existence, automatically subordinated them to male authority even when they ruled kingdoms in their own right. The result, foreign queens existed in a legal category that Roman jurisprudence deliberately left undefined, and that ambiguity wasn't an oversight. It was a weapon. Here's what we know for certain from surviving legal commentaries and historical accounts. When Cleopatra VII negotiated with Rome, she did so without legal standing. She wasn't a Roman ally, she was the lover of Roman generals who chose to recognize her authority as a personal favor, not a legal obligation. When those relationships ended, so did her legal existence in Roman eyes. The same pattern appears across 3 centuries of Roman expansion. Queen Zenobia of Palmyra commanded armies, administered vast territories, and minted coins with her image. The moment Roman forces captured her, she became legally invisible. Not a prisoner of war entitled to honorable treatment under Roman military law. Not a foreign dignitary with diplomatic protections. She was reclassified as the property of the emperor, paraded through Rome in golden chains during Aurelian's triumph, and the legal instruments authorizing this treatment are still preserved in Roman triumph records. Read that again. A reigning queen, captured in war, legally reclassified as property. Not through some barbaric exception to Roman law, but through its deliberate application. The machinery becomes even more disturbing when you examine what Roman jurists wrote about the legal status of conquered foreign women. Gaius, one of the most influential Roman legal scholars, explicitly states in his Institutes that foreign women captured in war become slaves by natural law ius naturale, regardless of their previous status. Queens, princesses, noblewomen, their rank meant nothing under this doctrine. The moment Roman forces took control of their territories, these women lost personhood under Roman law. They could be enslaved, sold, sexually exploited, or killed, and none of these actions violated Roman legal principles. In fact, Roman law protected the men who did these things. The ius gentium didn't just fail to protect foreign queens, it actively stripped them of legal recourse. Now understand what this meant in practice. When Rome conquered Macedon in 168 BCE, the royal women of the Antigonid dynasty, queens who had ruled as regents, who had commanded diplomatic negotiations, who had managed state treasuries, were distributed among Roman generals as war prizes. Contemporary accounts describe this as normal procedure. Livy mentions it in passing, focusing instead on the military glory of the conquest. Polybius, who witnessed these events, records that the women were appropriately allocated according to Roman custom. Neither historian expresses moral concern. Neither questions the legal framework that made this possible. And when later Roman legal scholars referenced these events, they cited them as precedent for how the ius gentium should be applied to foreign royalty. The silence is testimony. The absence of outrage in the legal texts, the bureaucratic language describing the distribution of royal women, the complete lack of legal debate about whether queens deserved different treatment than common captives, all of it reveals a system that had naturalized the abuse of foreign noblewomen to the point where it required no justification. But here's where the evidence becomes undeniable. We have the actual legal contracts. Preserved in papyri from Roman Egypt, in wax tablets from military archives, in stone inscriptions from triumph monuments, there are documents that record the transfer of foreign royal women as property. These aren't vague historical accounts. These are legal instruments with specific language about ownership, valuation, and permitted uses. One papyrus from the 2nd century CE records the sale of a Nubian princess, captured in the Ethiopian campaign, healthy, suitable for household service or breeding. Another document lists among the spoils of the Dacian Wars 3 royal concubines of Decebalus, valued at 15,000 denarii combined. These women had names. They had titles. They had ruled or influenced kingdoms, and Roman law reduced them to line items in property inventories. The legal mechanism that enabled this wasn't some obscure provincial corruption of Roman principles. It was gentium functioning exactly as designed. The law of nations, which supposedly recognized universal human dignity, contained an explicit carve-out for foreign women of royal status, not to protect them, but to legally facilitate their exploitation. Roman jurists debated extensively about the property rights of foreign merchants, the contract obligations between Romans and foreigners, the inheritance rights of children from mixed marriages. But when it came to foreign queens captured in war or living in Roman-controlled territories, the legal texts are remarkably consistent. They have no independent standing, no protected status, and no recourse to Roman courts for violations committed against them. This is the part legal historians rarely mention. The Digest of Justinian, compiled in the 6th century CE and representing the culmination of Roman legal thought, contains hundreds of fragments from classical jurists discussing the treatment of foreigners under various circumstances. When you search for provisions specifically addressing foreign noblewomen or queens, you find almost nothing. Not because Romans didn't encounter such women, but because Roman law deliberately refused to create protections for them. The absence is strategic. By not defining their legal status, Roman law ensured that their treatment remained subject to the discretion of whoever held power over them. And discretion, in the absence of legal constraints, meant abuse. Consider Queen Berenice IV of Egypt. She ruled independently after her father Ptolemy XII fled to Rome. When he returned with Roman military backing, Berenice was executed, not for treason against Rome, which never recognized her authority in the first place, but for the administrative convenience of restoring her father's rule. Roman legal texts mention her death as a matter of proper order being restored. No trial, no legal defense, no recognition that a reigning queen might have rights that required due process. The legal framework simply didn't acknowledge that foreign queens could be wronged by Roman power. Or examine what happened to Cartimandua, queen of the Brigantes in Britain. She allied with Rome, handed over Caratacus to Roman forces, and ruled her territory as a client queen for decades. When civil war broke out in her kingdom and she needed Roman support, the response was to annex Brigantia and place it under direct Roman military control. Cartimandua herself appears in the historical record one final time as a woman placed under Roman protection, which meant she lost all sovereignty and lived the remainder of her life in legal dependency, unable to own property, unable to make contracts, unable to act without male Roman guardianship. The gentium that had recognized her as an ally when she was useful provided no protection when she became inconvenient. Read the pattern carefully. Foreign queens who cooperated with Rome were granted informal recognition, not legal status, just the temporary goodwill of individual Romans in power. The moment that goodwill ended, they had no legal foundation to stand on. Foreign queens who resisted Rome were classified as enemies, and enemy women in Roman law had fewer protections than livestock. The gentium created a framework where foreign royal women existed in permanent legal precarity, their safety dependent entirely on male Roman discretion. And here's what makes this machinery so insidious. It was celebrated as enlightened. Roman legal scholars genuinely believed the gentium represented sophisticated jurisprudence. They wrote treatises praising its flexibility, its recognition of natural law principles, its capacity to integrate foreign peoples into Roman civilization. The fact that this same legal framework left foreign queens vulnerable to enslavement, sexual exploitation, and property confiscation didn't register as a contradiction. It registered as proper order. The legal texts describe the treatment of foreign royal women using the same neutral administrative language they used for aqueduct construction or grain distribution. The violence was bureaucratized, which made it invisible as violence. Now trace the consequences through the historical record. We know the names of dozens of foreign queens who encountered Roman power between the 3rd century BCE and the 5th century CE. We know them because Roman historians mention them in conquest narratives, in triumph accounts, in biographical sketches of Roman generals. But when you try to track what happened to these women after their initial appearance in the sources, most of them simply vanish. No death records, no mentions of exile, no accounts of their later lives. They appear, they're captured or subjugated, and then the historical record loses interest because Roman legal and administrative systems didn't track them as persons with continuing legal existence. They became property or dependents or concubines, and property doesn't get its own historical narrative. The ones we do have partial records for reveal the pattern clearly. Sophonisba of Numidia forced into marriage with a Roman ally, then forced to commit suicide to prevent her capture by a different Roman general. Teuda of Illyria, deposed by Rome, her final fate unrecorded because Roman sources simply stopped tracking her once she ceased to be politically relevant. Boudica, revolt crushed, probable suicide. Her daughter's fates unmentioned except for a single reference to their sexual assault by Roman soldiers that appears in Tacitus as an aside, not as a legal or moral crisis requiring examination. The gentium didn't protect any of them. It couldn't because it was never designed to. Understand the legal architecture that made this systematic. Roman law divided all people into clear categories. Citizens, Latins, foreigners with treaty rights, foreigners without treaty rights, slaves. Each category had defined protections and limitations, but foreign queens occupied an impossible position within this framework. Their royal status meant they weren't ordinary foreigners. Roman law recognized hierarchies and understood that nobles required different treatment than commoners. But their foreignness meant they weren't entitled to the protections Roman law granted to Roman noblewomen. And their gender meant that even the limited protections the gentium might have offered to foreign male rulers didn't apply to them. Roman legal theory held that women lacked the capacity for independent legal action and required male guardianship. So foreign queens, even when ruling in their own right, were legally incomprehensible to Roman jurisprudence. They claimed authority that Roman law insisted women couldn't possess, while lacking the citizenship that would have given them any protected status. The Roman solution to this legal impossibility was elegant in its cruelty. Simply refuse to acknowledge foreign queens as legal persons requiring protection. They existed in a space outside law, subject to power without recourse. And because the gentium was celebrated as a universal framework based on natural reason, this exclusion was naturalized as proper order rather than recognized as systemic violence. The evidence from Roman legal education makes this explicit. When law students in Rome studied the gentium, the standard examples used to illustrate legal principles came from actual historical cases. Foreign merchants seeking contract enforcement, provincial governors managing disputes between Roman and non-Roman parties, inheritance questions in mixed marriages. But when the topic turned to foreign rulers and their legal status, the examples used were almost exclusively male. The legal education system taught future jurists how to handle foreign kings as diplomatic and legal subjects while remaining silent on foreign queens. That silence wasn't an oversight. It was pedagogy. It taught law students that foreign queens occupied a category that didn't require legal theorizing because it didn't require legal protection. We can track this through the legal careers of prominent Roman jurists. Ulpian, Papinian, Paulus, these men wrote extensively about nearly every conceivable legal question involving foreigners. But when you search their collected works for discussions of foreign royal women, you find virtually nothing. Not because such women didn't exist or didn't interact with Roman legal systems, but because Roman legal thought deliberately excluded them from analysis. The absence is the evidence, and the consequences were generational. When Rome conquered a kingdom and legally erased its queen, her children became legally suspect as well. Mixed-blood children of foreign queens and Roman men existed in legal limbo, not quite foreign, not quite Roman, vulnerable to having their status challenged whenever convenient. The Ptolemaic dynasty in Egypt provides the clearest example. For 3 centuries, Ptolemaic queens ruled with real power. But Roman legal texts consistently refer to them in diminished terms, as consorts, as regents for male heirs, as women whose authority derived from their relationships to men rather than their own right to rule. When Rome finally annexed Egypt, Cleopatra's children were either executed or disappeared into legal non-existence. And Roman law treated this as proper procedure for dealing with the offspring of a foreign woman whose legal status had never been recognized. This changes everything we think we know about Roman law's supposed enlightenment. The gentium wasn't a framework for universal justice. It was a tool for managing imperial expansion in ways that protected Roman interests while creating legal cover for violence against conquered peoples. And foreign queens, because they represented both political threat and sexual availability, became specific targets of legal mechanisms designed to strip them of protection while maintaining the appearance of legal propriety. The definitive truth is this: The gentium legalized the abuse of foreign queens by refusing to grant them legal personhood. It didn't do this through explicit statutes authorizing violence. That would have been too obvious, too vulnerable to criticism. Instead, it did this through strategic silence, through categorical exclusions, through legal frameworks that rendered foreign royal women invisible to the protections the law claimed to provide universally. The machinery was administrative, which made it durable. It was legal, which made it seem legitimate. And it was celebrated as enlightened jurisprudence, which made it invisible as systemic violence. The law didn't just fail to protect foreign queens. It actively created the legal architecture that made their exploitation routine, bureaucratic, and morally untroubling to the jurists who designed it and the empire that benefited from it. If you've learned anything from this investigation into how legal systems can naturalize violence against the most powerful women in conquered societies, hit that subscribe button on Mythbusting. We're going to keep uncovering the mechanisms of historical oppression that legal and historical texts have worked for centuries to render invisible. What other legal framework that we celebrate as enlightened actually encoded systematic harm? Drop your thoughts in the comments below.